Hi, this is Jennifer Casanova. I just wanted to address something real quick that comes up a lot for people with court cases, whether it be traffic tickets or if it's, even with felonies. There are different ways that a case can be resolved. And a lot of times if you don't have an attorney, then you don't know the different ways or different options that you can ask for. One of the most common is a stay of imposition. And what that means is after your plea, the judge will order either a stay of imposition, a stay of execution, or a stay of adjudication. And what that means is how the case is put on the record. So, for example, let's say you plead guilty to a felony case and it has a presumptive of 60 months. A stay of execution means that the judge is not going to execute that sentence, although they will pronounce it on the record. What that means is you don't have to serve that unless you violate probation or are pronounced the executed sentence by a judge at a later time. A stay of imposition is staying or holding the imposition of the sentence. That means that the judge may order jail time or order STS, community work service, but they're not going to impose the executed sentence time. Now, that doesn't mean at a later time, if you violate probation, your stay of imposition can turn into a stay of execution. That often happens on probation violations for felonies. Now, the most favorite and the best one is a stay of adjudication. What that means is the judge actually does not accept your guilty plea, and if you complete probation and all of the terms of your probation remain law-abiding, any community work service, sentence to service, whatever is ordered, then at the end of probation, your sentence or your plea will not be adjudicated. I think of adjudication as like a stamp of a conviction. So essentially, you won't have any conviction on your record if you successfully complete a stay of adjudication. This is used a lot in traffic cases or other low-level offenses. A lot of times, some county attorneys will not allow stays of adjudication, but those are usually on felonies. A continuance for dismissal is a little bit different than a stay of adjudication, because a continuance for dismissal means that after a certain amount of time, if you've completed all of the things that the prosecutor asks, then they will completely dismiss the case, which is used for a lot of different things. A lot of times that's for first-time offenders or for low-level traffic cases, things like that. The difference between a stay of adjudication and a continuance for dismissal is that for a stay of adjudication, the conviction never goes on your record, and for a continuance for dismissal, they will dismiss the case entirely. Now, the thing about a stay of adjudication is that you've already admitted facts and that the judge can order that your stay of adjudication turn into a stay of imposition, and therefore the conviction can go on your record. A continuance for dismissal, if you don't complete everything that the prosecutor asks, then basically your case starts over. And usually that's 6 months to a year down the road, and there aren't any facts on the record, and the prosecutor has to prove up the case. So these are the different options that can happen with a case, and some of them are really useful tools in keeping a conviction off your record. I hope this helps answer some questions. Feel free to text me, email me, tweet me with any other questions. I'd be happy to answer and address in future videos. Thanks for watching.